No part of the following lecture material may be used without the express written consent of Rick Ramos or Contra Costa College. It's Professor Rick Ramos, and today we're talking about witness competency and credibility for legal aspects of evidence. So going back to previous chapters, we know that there are three basic tests for admissibility of evidence. The first is that it's relevant, and that was handled in Lecture 6. The next is competently presented, and last is it's legally acquired. So we're going to talk about competency today, and we're going to talk about witnesses. A competent witness is able to take the witness stand and give testimony in a proper fashion. The law presumes that all persons are qualified to be witnesses under 700 EC, regardless of age. That means that a 5-year-old witness can testify in court as to the identity of a person that they see come out of a window on a burglary. If the defense cares to challenge them, the burden of proof falls to the side who opposes a witness in court to prove incompetency. And this is done through a voir dire examination. A voir dire just means an examination to determine fitness. We do it in selection of jurors, and we also do it in selection of expert witnesses, and it can be done for the purposes of determining the competency of a witness. But the basic law in California is that all people are competent unless they're proven incompetent. So the prosecution could call an 8-year-old boy who witnessed child abuse at a daycare center to testify until the defense proves him incompetent. It could also be a situation where the defense intends to call an alibi witness who's totally nutso, has some mental illnesses. Despite the mental history of the person, the law presumes a witness is competent to testify until the prosecution proves that they're incompetent. The three-pronged test to determine if a person is competent to testify is the ability to observe and perceive. The second is the ability to recall and narrate. And the third is the ability to understand the duty to tell the truth. One challenge the competency of a witness is determined through a voir dire examination as previously discussed, and the judge has the final say. Let's identify and discuss witnesses with possible competency problems. The first would be young children. In California, theoretically, a child of any age can testify. There's no presumption that at a certain age a child is incompetent. However, the younger the child, the more likely the child will be unable to meet all three tests of competency. A child can testify if he or she possesses the ability to observe and recollect events, can understand and answer questions posed by the counsel or the magistrate, and understands the necessity of telling the truth. And there are a number of cases cited by the author in the textbook as to both ways of being accepted and not accepted. Second type of person would be somebody who's senile. And that means that the person's mental facilities have deteriorated with age. They may have senile dementia or Alzheimer's disease, and that may prove them to be incompetent because they're not going to be able to recall and narrate. Number 3, physically handicapped. Blind person or deaf person is limited in the type of testimony that they can give. A blind person could still testify about what they heard, and a deaf person could still testify about what they observed. Number 4, a person having a mental defective disorder. Someone who might be insane or an idiot may not be competent witnesses, and again, they would have to be tested. They may also be under the influence of a temporary defect that causes them to not be sane, such as an intoxicant. A person might be high on drugs, and that might affect their ability to be able to observe or perceive. The fifth would be foreign-speaking persons. These persons may not have the ability to narrate in English, and the law will appoint an interpreter if necessary to handle that sort of situation. Now, interesting category of person who may not be qualified is hypnotized persons. As I was leaving police work in 1988, I found that our department was using one specific inspector who learned how to hypnotize witnesses and victims, and he was able to get license plates, descriptions of persons that maybe the person had blocked out subconsciously. In California, persons who have been hypnotized are incompetent to testify as to any information recalled during or after a hypnosis, and this comes from the Shirley case in 1982. The reason for this is there's a high probability of hypnotic suggestion and memory change, and investigators may use facts disclosed through hypnosis as investigative leads, but the person will not be able to testify. So a lot of that has to do with what did they give you as a statement pre-hypnosis, and what did they give past hypnosis. If you're going to use a statement pre-hypnosis, it has to follow the following rules to be admissible. A, the witness consents to hypnosis. B, the pre-hypnotic interview is memorialized, meaning it's recorded. The hypnosis, induction, and interview are conducted by a licensed physician or paraprofessional or police hypnotechnicians. D, the statement under hypnosis is also memorialized or recorded. And the judge reviews all the tapes concerning pre- and post-hypnosis to determine what was said. There is an article you can review on child witnesses on slide 6 of my notes, just for your information. The next topic is credibility. Credibility is the believability or weight given to the witness testimony by the judge or jury. How much did they believe what this person said? During the jury instructions at the end of the trial, the judge will remind the jury that all persons are competent to testify, but the jury has to decide on what weight they're going to assign a witness's testimony. And the following are different characteristics that they might bring up for the jurors to deliberate over as far as giving weight to testimony. They include the length of time the witness had to observe the alleged criminal act and the suspect, the stress, if any, to which a witness was subject to at the time of the observation, the witness's ability to provide a description of the suspect, the extent to which the perpetrator either fits or doesn't fit the description provided, the cross-racial and ethnic nature of the identification, meaning that the victim could be black and the suspect could be white, or the victim could be black and the suspect could be black, and the victim could be white and the suspect could be black. Can they identify somebody out of their own culture? Next, the witness's physical and mental capacity to make the identification. Next, whether the witness was able to identify the alleged perpetrator in a show-up or lineup. And then the lighting, the distance, the weather, and other physical conditions present, the period of time between the alleged criminal act and the witness identification, and whether the witness had prior contacts with the alleged perpetrator, whether that person was known to them. Next, the extent to which the witness is certain or uncertain of the identification and the fact that the witness made consistent identifications. And last, whether the witness identification is in fact the product of the witness's own recollection and not the result of influence or suggestiveness. Now, one of the things that I'll tell you, I had a homicide case, and I remember the victim's name was Roosevelt Brown, and two suspects, later identified as Virgil Luckett and Melvin McCullough, both members of the Black Guerrilla family and out on parole for numerous felonies, had been seen dragging the victim out of the Till 2 bar down near Alcatraz and Shattuck in Berkeley. And I happened to find a witness who knew both those suspects and was able to put a photo lineup together and really quickly identified them. So this was done in such a short amount of time, and the person was known to them, that it was very credible and had great weight in court. The next topic I want to talk about is impeachment, and that means to attack the credibility of a witness or to lower or lessen the weight of the witness's testimony in the mind of the jury or the judge. And there's a number of different things that we would use to impeach testimony. First is physical or mental state of the witness. And the way we would do this is show that maybe the person had a handicap, they didn't have good eyesight, their hearing was terrible. If you can remember My Cousin Vinny, which is a comedy about a young Bronx lawyer who's going to defend his cousin who's arrested for a murder in the South, he puts a little old lady on the stand and she says she absolutely identified the suspects. And then he goes back about 50 feet and he raises his hand up and she's unable to tell him how many fingers he had up. And this was a good way to impeach her eyesight and whether or not she could see this. Another physical or mental state of the witness could be whether they were under the influence of alcohol or drugs, and you could use this to say it impaired their ability to make an identification and know what happened. Or if there's a substantial time lapse between the crime and the time the person is identified. As a young man, about 18 years of age, I was robbed at gunpoint down at Market and 13th Street in San Pablo, now called Rumrell, at a little hamburger stand called Hambricks. The guy came up and he stuck a gun in my rib cage, and I was sitting in the car. The door was open. I just got seated, and he put the gun on me and he robbed me, and I had to drive him to North Richmond, and then found out the gun was empty, and it was time for some attitude adjustment for him once I found out it wasn't a gun. But the guy did get away, and we went to San Pablo PD, and they showed us a photo lineup of some suspects, and this was about 3 or 4 days later, who they believed were involved in a robbery series, and we were able to identify the suspect, and the suspect was later arrested. And so we never had to testify in court because the guy knew he did it, and he was scared. But it would have been an interesting experience for me, and I'm sure they would have tried to impeach my testimony because it had been 3 or 4 days since the crime had occurred. Would have been much more credible, or would have had more weight with the jury if they would have caught the guy in the general area. The next ground for impeachment could be bias, interest, or other motive in the case. And we use this a lot with what we would call jailhouse informants or accomplices who rat out their partners. An accomplice is a person who commits the crime with the defendant, but then turns state's evidence and is going to testify against them. And so you might say that there is a conflict of interest there and that the person's going to do it to save their own hide. A witness with a financial interest in the case would be one whom, if the defendant is found guilty, they're going to actually benefit financially from the situation, and you might be able to impeach their testimony. Other grounds might be that the person has a relationship to the party in the case. Might be a brother, might be a sister, or someone that's trying to protect their family. The next area that we're going to talk about after bias is character evidence. And this goes back to the times of Hammurabi, where in early history, the times of Hammurabi, Roman law, European law, you had a term called compurgation. And what that meant was that you would come forward and be a witness of the reputation for honesty, integrity, and truthfulness of the defendant in the case, hoping to get them off. It's interesting that the author touches on Pitch's motions, where when you're dealing with honesty or reputation, you have a scenario where a police officer testifies she used reasonable force in effecting an arrest after the defendant hit her several times. The defendant counters that he hit the officer in self-defense because the officer was using unreasonable force when beating him with a baton. The defense will attempt to obtain names of persons from the officer's personnel file who may have alleged past acts of unnecessary force used against them. This is called a Pitch's motion. These persons could be called as character witnesses to impeach the officer's testimony. The defense may use the same procedure to disclose evidence from personnel files that an officer was untruthful or lied during an internal affairs investigation. This is Maryland versus Brady. Now, this is the exact situation that currently in 2009, there are a number of Oakland police officers who are found to be not providing truthful information on search warrants. If Oakland police do not fire those officers will always be dragged through the mud because their integrity will always be challenged, and it will be shown that they were untruthful in internal affairs matters also. So they probably have no choice but to get rid of these poor officers because of their future ineffectiveness in a court of law. If you were a chief of police, do you want officers on your department that jurors are not going to believe because they're not going to ever get convictions on arrests? We can also bring up character witnesses to show that a person is not honest if they have prior felony convictions involving moral turpitude or willingness to do evil. And what I mean by that is they steal or they hurt people. Examples of crimes that would fit that would include arson, assault with a deadly weapon, auto theft, burglary, child abuse, cohabitation abuse, escape, felony DUI with injury, felony evading, etc., etc. There are numerous examples given by the author. The fourth area is Manner of testimony, inconsistent or contradictory testimony. This is one that you'll see happen a lot, and this is where we're dealing again with impeachment. We are in the fourth area of common grounds, and it could include witness demeanor. Witness displays an obvious prosecution or defense bias through body language or voice inflection in the manner of answering questions. So you feel like they're really trying to push one side or the other instead of just giving information. The other area that we would attack credibility would be when the witness gives inconsistent statements. They gave one statement to one officer and then it changes later on. Then in court, they also give a third rendition of the statement. They're not consistent, so the jury will give them less weight. One of the ways that we protect the credibility of witnesses is to have them segregated before they testify. It's important that you separate witnesses at the scene when you're interviewing them because you don't want them to influence each other. I once had a little old lady who obviously wanted to be the center of the limelight as far as my investigation went, but she was unsure about the description of the suspect, and it was obvious that she had really bad eyesight. There was a young man who was probably about 12 or 13 who was positive that the person that we had stopped was the suspect, and this little old lady basically berated him, telling him that he was wrong, and we immediately segregated him, and she was told to just leave him alone. So in that case, it turned out that the young person had better eyesight and was more credible than the older person who had bad eyesight. You need to be careful, too, that you don't violate Miranda and think you're going to be able to get on the stand and use inconsistent statements, because in a case called Stelling in 91, the DCA basically stated that inconsistent statements taken in violation of Miranda cannot be used to impeach the credibility of a defendant's testimony statements, but can be used to argue consciousness of guilt. In a case called James in 1990, the court said the defendant's inconsistent statements cannot be used to impeach a defense witness who testifies contradictorily to the defendant's statements. And in a case called Havens, evidence seen in violation of the Fourth Amendment is inadmissible for limited purposes of impeaching the defendant's testimony if the defendant testifies in conflict with the previously recorded or recovered evidence. This includes a robbery note and narcotics paraphernalia. Evidence itself is not admissible as evidence, only the inference drawn from it that the defendant's testimony is inconsistent and should not be believed. So basically, if you violate the Fourth Amendment, although you can't enter the evidence into court, you can use the information gained from that evidence to draw an inference as to the fact that the defendant is lying if they testify. Later on, you're going to learn that if you violate Miranda and the person gives you a statement, then they get on the stand and lie, you can actually use that information to impeach their testimony, but that's very, very rare. It's the only time you can. And you always want to do a good job on your investigation because you don't want to be impeached yourself. If an officer fails to collect or preserve physical evidence at a crime scene, although not due process grounds for dismissal, failure to follow established police procedures can be used to impeach the officer's testimony and the overall thoroughness of the case investigation. That's really what happened in the O.J. Simpson case. There are plenty of retired guys that will come on the stand and money quarterback you and say what a terrible job you did and how, in fact, you jeopardized this whole investigation, that the defendant should be set free. So you need to be careful and do a good job right from the get-go. The police reports also have to be high quality in nature, because if you have a lot of spelling and organizational errors, it's basically going to say that you're inaccurate and disorganized, and maybe your whole investigation is inaccurate and disorganized, and you have the wrong defendant on trial. So do a good job. The last topic in this lecture is rehabilitation. And rehabilitation means to bolster or lend support to credibility of a witness. Rehabilitation is the hopeful outcome of redirect examination. So here's how it goes. When you bring somebody up, it's direct examination. When the other side gets a turn at them, it's cross-examination. Now, if they impeach them a bit about their testimony, then in redirect, which is the third level, you get to try to rehabilitate their testimony. And then lastly, they get recross, where they try to damage your testimony again. The textbook refers to a great example, and this is an example of a witness testimony. While jogging, a college student is victim of a sexual battery. The suspect is detained in the vicinity of the report, so contemporaneous to the crime. The suspect is positively identified during an infield show-up and arrested. He bails out on the crime and runs from the area. He's later arrested on a bench warrant 10 months later. At trial, the victim believes the defendant is the attacker, but is unable to positively identify him due to the fact that he has cut his hair, shaved his beard, gained some weight, is wearing glasses now, and is dressed totally different than the night of the attack. So they're going to try to impeach her testimony based upon the fact that she can't identify him in court. But the victim's identification could be rehabilitated using prior identification. Because the identification was made shortly after the occurrence of the crime, the investigating officer would be able to take the stand and testify the victim identified the defendant during the infield show-up. Second, the investigating officer should have taken photographs of the defendant after arrest. The officer could authenticate these photographs and have the victim identify him. Her identification testimony would then be rehabilitated and should carry more credibility with the trier of fact being the judge or the jury. There are a couple other examples I would like you to look at the end of this chapter. So let's do a little bit of a review. What's the difference between competency and credibility? Competency is where we believe that a person is able to testify. Credibility is the weight given to the testimony by the trier of fact. What are the tests for witness competency in California, and which side carries a burden of proof to show incompetency? The answer is it's a three-pronged test. Can you remember what they are? Ability to observe or perceive, ability to recall and narrate, in other words, explain what happened, and lastly, understand the duty to tell the truth. The burden of proof to establish incompetency goes with the side that wants to challenge a witness. Name 4 problem areas where a person could possibly be judged as incompetent witness after a voir dire examination. Young children, senile persons, physical handicap, mental handicap, foreign-speaking persons, or hypnotized persons. Name 3 common areas where witness testimony can be impeached. Physical or mental state, bias, interest, or other motive in the case, or their character, inconsistent, contradictory testimony. What is the purpose of segregating witnesses? Hopefully you understand so they don't influence each other. Make sure you read the chapter, go over your study notes. I'm hoping that you're printing out the study notes or PowerPoint slides and you're using the note part to take notes as I'm explaining the slides to you, because that's really what you got to do. If you're trying to just listen to this and not look at the notes and you're not writing, you're not going to remember anything and you're going to have a really tough time. Remember, when you study, if you just listen to it, you only hear half of what is said and you only remember half of that. The way that you develop a memory of the information and place it in your subconscious is when you see it, you hear it, and you write something. You have to do something physical, so it's important that you do something physical. Okay, this is Professor Ramos. This is the end of lecture number 7 on witness competency and credibility. Have a great day, and you'll be hearing from me real soon.